Good morning, everybody. Welcome to the Law Enforcement Data webinar with the Data Practices Office. Thanks for joining us. Data Practices Office is a statewide resource on data practices in the open meeting law. Most of what we do is just answer questions related to those laws from members of the public and government. So please feel free to reach out to us if you'd like to discuss a data request, a classification, or whether a meeting can be closed. We also provide training on different data practices and open meeting law topics. We're hoping to transition our in-person workshops to an online platform this fall, and then also continue these short webinars. Our webinars are recorded, so if you missed part of the Q&A today or you want to go back and hear something again, it will be posted on our YouTube page within the next couple of days. Today's webinar is the fourth part in our 5-part series on law enforcement data. If you missed any of the first 3 and you'd like to revisit them, I'll show you how to find those videos on our website, which is the link on the screen here. All right, so this is our website. If you go to our website, I just want to show you where you can find some resources on law enforcement data as well. If you go to this Data Practices tab at the top of the screen, scroll to Types of Data, and then go to Law Enforcement. We have a lot of information here that might be helpful for you. Otherwise, our YouTube page, you can find it on the YouTube icon at the bottom of your screen, or you can go to News and Events and Webinars. On our webinars page, we have some audio FAQs if you're having any issues today. We also are posting all of our presentation slides from all of our webinars on this page now. So if you want a PowerPoint from any of our previous webinars, you can find them here, and we'll be posting the presentation from today on here as well. Again, our YouTube channel is here. Once you go to our YouTube channel, you can see all of our videos on the videos page. Otherwise, you can click on playlists, and we have a different playlist that features each of our webinar series. And so law enforcement webinar series is the most recent one, and we'll be adding this webinar later. All right, so if you want to download a copy of today's PowerPoint, I'm also going to share the file with you now. All right, so you should see the download available in a pop-up box on your screen. If you want to download it, you can do so. Again, you can download from our website later on if you want to as well. So today's webinar, we're covering law enforcement data on juveniles. We're going to leave some time for a Q&A session at the end. Feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in the questions, please send them to all panelists so we can be sure to see those. All right, 260B171 is the primary statute you can look to for law enforcement data on juveniles. This statute refers to this data as peace officer records on children. There are a few other provisions that address juvenile data, which we'll mention throughout the webinar today. Because of the various statutes involved, these juvenile law enforcement data issues can be tricky. So if you ever have any questions regarding juvenile law enforcement data, please feel free to give us a call, and we're happy to discuss those. All right. Peace officer records on children are data that are maintained by law enforcement about alleged or delinquent juveniles, or juveniles who may be engaged in criminal acts. Most peace officer records on children are private, with a few exceptions. This statute takes these records on juvenile delinquents out of 1382 and classifies them as private. So there's no confidential data about juvenile delinquents during an active investigation. and much of the data remain private once the investigation is inactive. Although the data are classified as private, law enforcement can withhold data if disclosure to the juvenile or the juvenile's parents would interfere with an ongoing investigation. And I put the site for that provision on the slide for you. It's subdivision 5A4. An exception to the private classification for peace officer records on children is when the hearing for the offense will be public. Generally, hearings are public when a juvenile is at least 16 years old and commits a felony level offense. This includes situations where children are tried as extended jurisdiction juveniles through the process that's outlined in 160B.163 as well. If the juvenile is younger than 16 years old, the hearing will only be public if the juvenile is certified as an adult when they commit a felony offense and are at least 14 years old. Okay, so who can you release juvenile data to? 260B.171 indicates that private data on juvenile delinquents must be released pursuant to a juvenile court order and to the child or the child's parents or guardian unless the disclosure would interfere with the ongoing investigation. There are also 3 potential reasons law enforcement may be required to release juvenile data to schools. The first is as required by Section 121A.28, which states that law enforcement must report a drug or alcohol violation to a school's chemical abuse pre-assessment team if there's probable cause to believe that a K-12 student committed the violation. The second is that unless notice would jeopardize an ongoing investigation, law enforcement must notify the superintendent if there is probable cause to believe that a juvenile committed an adult crime, the victim is a student or staff, and notice is reasonably necessary to protect that victim. Notice to the school is also required if there's probable cause to believe a juvenile committed a serious crime, regardless of the victim. In serious crimes, those include murder, manslaughter, criminal vehicular homicide, assault, robbery, criminal sexual conduct, arson, terroristic threats, possession or use of dangerous weapons. So those would be what serious crimes constitute reporting to school as well. The third reason why a law enforcement agency might need to report to school is if a probation officer, they have to provide a copy of the disposition if a juvenile is adjudicated delinquent for an act that is either committed on school property or is one of the statutory listed adult criminal offenses. The probation officer must also notify the juvenile's parents about the disclosure and notify the school that it may get additional information with parental consent. The probation officer also has to notify the school when the student's discharged from probation as well. And I listed the statutes for each of those requirements on the slide in case you want to go back and review those. There's also limited public arrest data on juveniles in 1382 subdivision 2J, which indicates that the age and sex of an arrested juvenile are public, but all other arrest data must be redacted or withheld from public because they're private 260B.171 data on juveniles. There are also 2 provisions that require data on juvenile offenders to be released to victims. So 260B.171 indicates that a victim can make a request in writing to the prosecuting authority to release investigative data to the victim. This is similar to that provision in 1382 for victims as well. In this situation, the prosecutors can withhold data if they reasonably believe releasing the data would interfere with the investigation, or that the release is motivated by a desire to engage in unlawful activities, or it's prohibited under 13.821, which is the statute that addresses videotapes of child abuse victims. The second provision is in 611A.56. The Victims' Reparations Board may request from prosecutors and law enforcement data that's necessary for processing claims for crime victim reparations as well. So law enforcement are also permitted to share data on juvenile offenders to other law enforcement agencies if the exchanged information is pertinent and necessary for the law enforcement purposes. Also, in any county in which the county attorney operates or authorizes the operation of a juvenile pre-petition or pretrial diversion program, a law enforcement agency or county attorney's office can provide the juvenile diversion program with data concerning a juvenile who's a participant or is being considered for participation in that program. One more potential sharing is that upon request of a local social services agency, records on juvenile delinquents may be shared with the social services agency to promote the best interests of the subject of the data under 260B 171 subdivision 5G. Okay. Juvenile witnesses and victims. If the law enforcement records are about a juvenile who is simply a victim or a witness, so the juvenile did not or is not suspected of engaging in a criminal act, then these data are generally addressed by 1382 subdivision 17, protected identities, rather than 260B 171. But if the juvenile witness or victim is also a delinquent or alleged delinquent, then the data are governed by 260B 171 subdivision 5. For juvenile witnesses who are not delinquent, 1382 subdivision 17G indicates that these data should be protected when access to the data would reveal the identity of a juvenile witness and the agency reasonably determines that the subject matter of the investigation justifies protecting the identity of that witness. So the protection is not automatic, and law enforcement needs to make a determination that the subject matter justifies protection in order to do so. For juvenile victims who aren't delinquent, 1382 subdivision 7 protects the identities of the victims or alleged victims of criminal sexual conduct. Subdivision 17 also protects the identities of victims who request not to be identified publicly unless law enforcement determines that revealing that identity wouldn't threaten the person's safety or property. I just want to note here that there are also specific protections for child abuse data in subdivisions 8 and 9 of 1382 and in 626.556, which has now been renumbered as Chapter 260E. If you want more information on these protected identities, we covered protected identities in detail during our first webinar in this law enforcement series, and that video is currently up on our YouTube page. Okay, traffic accident data on juvenile traffic offenders involves the analysis of 4 separate provisions. I listed the main statutes on the top of the slide for you. It's 16909, 260B 171, 260B 225, and we still have 1382 that comes into play. So generally, traffic investigation reports are open to inspection by a person who was physically harmed or sustained an economic loss as a result of the traffic accident. 260B 171 indicates that identifying information on juveniles who are parties to traffic accidents can be disclosed as authorized under Section 1382, Subdivision 6. And Subdivision 6 includes limited information on the parties to traffic accidents, such as the dates of birth of the parties involved. Further, the state accident reports that are governed by 16909 may be released under Subdivision 13 of 16909 unless the information would identify a juvenile who was taken into custody or who is suspected of committing an offense that would be a crime if committed by an adult. Or would associate that juvenile with the offense, and the offense is not an adult court traffic offense under Section 260B 225. So I'm going to go into this in a little bit more detail because there's a lot of information here. But if the offense is an adult traffic offense under 260B.225, the data are public. So 260B.225 indicates that an adult court traffic offender is a juvenile who is charged with an adult court traffic offense and was at least 16 years old at the time of the offense. These offenses include petty misdemeanor traffic violations of a state or local traffic law, suspected DWIs, or suspected misdemeanors, gross misdemeanors associated with a DWI. So adult court has jurisdiction with these offenses and makes the identities of 16 and 17-year-olds with these adult court traffic offenses public. And then we have major traffic offenses, which are generally all traffic violations that aren't adult court traffic offenses. These major traffic offenses are handled by juvenile court, and as a result, the juvenile offenders' identities are still protected by 260B171. So the identities of the juveniles are private. These major traffic offenses may include juveniles who are simply taken into custody, juveniles suspected of committing adult-level felonies, juveniles associated with adult-level felonies, and 16 and 17-year-olds who are suspected of misdemeanors or gross misdemeanors. So I just want to go through a scenario to apply those juvenile traffic offender provisions. In this scenario, a reporter asks to inspect police department records about an accident involving two juvenile drivers. Juvenile number 1 was charged with driving with a suspended license, a misdemeanor, and juvenile number 2 was charged with a DWI. Can the reporter inspect the juvenile's records? Okay, we're going to start with juvenile number 1. We don't know the ages of these juveniles, so we're going to go through the analysis of what happens if they are 16 or older, and then what happens if they are younger than 16. Juvenile number 1 committed a misdemeanor, which is considered a major traffic offense. For 16 and 17-year-olds, this doesn't rise to the level of an adult court traffic offense, so the offense would be handled by juvenile court, and the juvenile's identity is private. If the juvenile is under 16 years old, original jurisdiction is still in juvenile court, so again, the identity is private, so the reporter could not inspect juvenile 1's records. Moving on to juvenile number 2, if this juvenile were 16 or 17 years old and were charged with a DWI, this would be considered an adult court traffic offense. So the proceeding would occur in adult court and be public, and the classification in 260B171 doesn't apply. Instead, Section 1382 would govern access, just as if the juvenile were an adult. So the reporter could get the super public 2, 3, and 6 data about juvenile number 2 while the investigation is active. But when it becomes inactive, most of the data about juvenile number 2 will likely be public under 1382 subdivision 7. Now, if the juvenile number 2 was charged with a DWI but was younger than 16 years old, juvenile court would still have original jurisdiction. So the identity of the juvenile would be private, and the reporter could not have access to those records. Okay, we're going to do a second scenario here. A data subject requested all police reports where she is mentioned. There is one responsive report dating back to 2002 when she was arrested along with 2 other juveniles who are also mentioned in the report for non-DWI misdemeanors. All 3 are now adults. What is the appropriate response to her request? Peace officer records of children are private under 260B171, subdivision 5. These are not adult traffic offenses or offenses with a public hearing, so whether the other juveniles were older or younger than 16 at the time of the offense doesn't matter. Private data are also only accessible to the data subject or those within the entity that have a work assignment to see the data. So here, the requester, she can have the data about herself, but she can't have the data on the other juveniles. The names and other identifying information on the other juveniles are private data, and those have to be redacted. Something to note here is that although the juveniles would all be adults by now, the data were classified as private 260B 171 data because of the age of the data subjects at the time of creation, so at the time of the offense. The classification doesn't change just because the juveniles are now adults. Okay, so we have some time for questions. Please send them in to all panelists in the Q&A panel. While you're thinking about your questions, I just want to mention another office in the Department of Administration, the State Demographic Center. They are leading the work on the 2020 census this year. We're highlighting this work because a good census is the foundation for a fair democracy, and we know that you all want to be counted, and the folks that you work with and serve want to be counted as well. You can learn more at the website listed here. This is going to allow Minnesotans to keep a representation in Congress and get funding for needed services. I'm going to put the PowerPoint up again. So for those of you who missed it the first time around, you'll have an opportunity to download it while we are taking questions. If you hear pause or some silence, don't worry. We're just making sure we get to all of your questions and reading those as they come in.
Okay, it looks like we have a few questions here. As you see from the presentation, you're sometimes bouncing back and forth between 2 statutes or maybe 3 or 4. So sometimes these questions and these issues can get quite complex. Always, please feel free to call us and walk through your determination or your analysis. We're happy to be that sounding board and discuss these issues with you. So one question is, can a guardian ad litem receive otherwise private data on a juvenile? That's a great question. There isn't anything in Chapter 13 or those provisions in 260B, either 171 or 225, that identify a guardian ad litem as somebody who can get access. Usually we look at the definitions in the Data Practices Act in 13.02, and they identify the data subject, which would be the child, or their parent or guardian, or a person who's acting in the place of a parent or a guardian. But since a guardian ad litem is really representing the best interest of the child and not actually that literal representative of the child, that guardian is probably going to need a court order. When they were appointed, there probably was a court order around the things that he or she could get access to. So in that court order, hopefully they will also, the judge will also include ability to get law enforcement data that may be private. Another question is, a juvenile victim of child neglect, can the parent, legal guardian, who is also the suspect, have access to the reports? So that is going to have some crossover between 1382, subdivisions 8 and 9, and the new provisions in Chapter 260E around maltreatment of minors. And basically, the data are private, identifying data are private about alleged victims or victims of neglect or abuse. And that does mean that a parent gets access even if they are the suspect. I'm sorry, the question said, who is also the suspect? So can the parent or legal guardian who is also the suspect have access? So generally, parents and legal guardians do have access to the private data of their child or the child that's under their care, unless there is some legal instrument or court order that has severed their rights, so they don't have rights to that child anymore. So unless there is a court order, they would get access to their child's private data in a neglect situation. Can the parent of a juvenile get a private report about that juvenile after that juvenile is an adult? Again, good question. This is that kind of timing, aging out question. Once a juvenile becomes 18, their rights are fully vested in themselves. So whereas when they were 17 and 11 months, their parents could get access to their private data. Once they turn 18, their parents cannot get access to their data unless they have a court order. All right, and another person had a similar question to that. Can a juvenile sign a release to waive to allow the information to be provided? Yep, this is a difficult question, it's not clear. The Rights of the Data Practices Act vests in a data subject, and a data subject includes the child. It also includes their parent. So generally for private data, I think that you have to take it on a case-by-case basis, on a child-by-child basis. Are they someone who is 5? Are they someone who is 17 and very mature? Maybe they're a very mature 13-year-old. It's going to depend. Consent has to be not coerced, and they have to understand the consequences of giving consent. So if you have a child that is able to do that, that would be their right, and I think you would be able to make that determination. So this is another question about limits on parents. Are there limits on parents getting data on their juvenile children? So again, generally no, as long as rights haven't been terminated or some sort of court instrument, maybe even in a divorce decree, some sort of court order, unless there is a court order saying that a parent cannot have rights to their children or don't have any legal rights to their children anymore, they do have access to the public and private data about their children. Can an attorney sign a subpoena to get private juvenile documents without seeking an order from the court? If the attorney is the direct representative of the child or direct representative of the parent who would be acting on the child's rights, it would be up to each entity to decide, but generally if they have a letter of representation saying, you know, I am the representative of this child or this parent, that is generally enough. If they're an attorney that is not in that direct client relationship with the child or parent, yes, then a court order is required. A subpoena is not going to be enough.
We have a question. What if parents had rights to a juvenile on a specific date for specific report and then lost parental rights? Can they get a report when they from when they had rights at the time of the incident? So what matters is whether they have legal rights at the time they make the request. So the child still has to be a juvenile at the time they make the request, and they have to be a parent or legal guardian of that child.
What is the best way to verify whether there is or is not any court orders in place that would prevent data being released? This is a great question. I think it comes down to more of a process question for each government entity who might be receiving these requests. In order to get private data, an entity needs to verify the identity of the requester, because private data can only be seen by the data subject, people within the entity who need it to do their business, those with consent, and those with a court order. So you have to verify the identity, if you're a government entity, of a data subject requester for private data. So whatever your policy or your process is, you would want to follow that. So if you're getting a request for private data and you're not sure if that parent has the right to get the data, you might have to reach out to, if there's another parent, or if you are familiar with the case, to the juvenile or the representatives of the juvenile, just to make sure that that parent does have access. A lot of these times, the requests come in within a certain context or certain circumstances, and the entity is familiar with what's happening and maybe knows the parties. That's not always the case, but that is often the case. And so the entities are able to figure out whether or not there's something that would prohibit that parent from getting access. All right, a juvenile crim sex conduct suspect, is the age still public? So if this is where you're going back and forth, we start into 260B.171 subdivision 5 to determine would the proceeding be public around the offense? If yes, then we classify all the data under 1382, just like that juvenile is an adult. So you would actually get name, address, all of that stuff. If it's an offense where the juvenile court is going to have original jurisdiction and it's going to be a closed proceeding or a closed hearing, then you are in 260B171, which says that you're only going to get limited identifying information under 1382 subdivision 2, which are just age and sex. So will depend on the offense and whether the hearing is going to be public. All right, I see that we are actually at our time. We have a couple other questions that we will follow up with later, but I think we've gotten to most of them. Thank you, and thank you for staying with us an extra minute. Watch for the fifth part of notice about the last fifth part of our law enforcement series, which is going to just be a general Q&A, and I think we'll try to talk a little bit about some legislative changes from the regular session and special session. That will come out soon. But thank you for spending time with us today, and we look forward to speaking to you soon.